Hello, I'm Lisa Gilday-Marega and I specialise in family law. If you've separated, it's going to be important that you reach a property settlement with your former partner. By property settlement, I'm speaking of a finally binding legal agreement that deals with the division of property with your former partner. Some people choose not to have an agreement like this and simply go about dividing the property pool on an informal basis. But these people run the risk that their former partner may come back later claiming to be entitled to additional property. You will want to be able to draw a clean line in the sand so that you can get on with planning your life without the worry of a possible future claim. So it's very important that you have an effective agreement in place. If your former partner is agreeable, this can be done by obtaining consent orders or by creating a binding financial agreement, and I'll be happy to discuss these options with you. The Family Law Act, which is a Commonwealth Act, addresses the way courts deal with property division. But even where you are not in court, it is still important for you to know how the Family Law Act will apply to your situation so that you can then understand what is your likely entitlement to property at law. This will guide how you and your former partner approach discussions about property division. For most people, the law has a four-step approach when it comes to working out what each person in the relationship receives as part of a property settlement. The first step is identifying the property pool or asset pool, which means the assets and liabilities that are available for division with your former partner. This will include all property, whether held jointly with your former partner or held by either of you, as well as property held by any company which either you or your former partner controls. What is considered property is actually very broad. It means all kinds of property. So this will include real property, cash, cars, boats, share portfolios, family businesses, superannuation, and even your furniture and personal effects. Basically, anything the parties own that has a value at the time of agreement or trial if your matter is in court. The second step looks at contributions which each of you has made to the property and growth of your asset pool. If either of you had assets or liabilities at the beginning of your relationship, this will be considered, as well as contributions that you made during the relationship, such as income earned, larger gifts and inheritances. Non-financial contributions such as childcare and home care services are also considered and treated as just as important as income and other financial contributions. All of these contributions are weighed up to determine the relative contributions that each of you and your former partner have made to your property pool. The third step involves what we call future needs factors. The purpose of this step is to consider how the financial position of each of you and your former partner is likely to be affected in the future by looking at certain existing factors. Future needs are assessed to see what adjustment, if any, ought to be made in favour of you or your former partner. There are numerous future needs factors. They include the age and health of each of you and who has responsibility for children of the relationship. There are other factors, but these are examples of some that will often apply, leading to an adjustment in one person's favour. The fourth and final step is considering whether a division of property is just and equitable. This does not mean making sure the division is fair or equal, but instead it's looking at whether each person is getting what he or she needs and deserves, taking into account contributions as well as the future needs factors. At LGM Family Law, we are passionate about achieving the best available outcome for our clients. Our goal is to do this through a process of negotiation, or where necessary, mediation, so that an amicable settlement can be finalised with your former partner. There will be times, however, when it becomes obvious that a settlement that involves a just and equitable outcome for our client is not going to be possible without taking an action in the courts. So you will need careful advice about a number of factors, including likely costs and outcome if you are successful at court, before you make a decision whether it's going to be worthwhile to take a legal action at all. At LGM Family Law, we will advise you about these things. If your decision is to go to court, we have the expertise to prepare your court documents and to diligently pursue your claim in the courts. At the same time, we will continue to look for opportunities for you to settle your matter by agreement with your former partner and cut the process of court short. We encourage our clients to finalise arrangements for the care of children at the same time or in tandem with property settlement. Ultimately, your children need certainty and to be reassured that both their parents will continue to be an important part of their lives. I want to remind you that this is just an outline of the principles relating to property settlement. I encourage you to obtain comprehensive legal advice about your situation and to start that process early towards reaching agreement with your former partner. I'm Lisa Gilday-Moraga. If you have any questions, I'm happy to speak with you over the phone on a complimentary basis during our initial call. I can also meet with you in person or speak over the phone if you prefer for a fixed rate initial consultation where you will receive more comprehensive advice tailored to your particular circumstances. Please feel free to contact me at LGM Family Law. I look forward to hearing from you.